A hugely significant order for the banking sector that affects the rights of borrowers as well as the concerns of lenders against default. So what is this Supreme Court judgment? What does it mean for the stakeholders? Well, at the heart of the issue is a 2016 circular issued by the RBI that armed banks to unilaterally declare accounts of willful defaulters as fraud. The Supreme Court has taken away that unilateral power, noting that it poses risks of arbitrary orders. So what exactly has the Supreme Court held? Well, in short, the Supreme Court has upheld the Telangana High Court judgment. The Supreme Court held that borrowers must be issued a notice and should be allowed a hearing before being declared as fraud. The Supreme Court holds that banks can't be allowed to exercise this power arbitrarily. The Supreme Court declared that principles of natural justice require that the affected party is given at the very least a hearing. But speaking of reasons, what are the Supreme Court's reasons behind stripping banks of this unilateral power? Well, the Supreme Court held that declaration of fraud by the bank has serious consequences, both penal as well as civil. Penal because the bank is required to file an FIR post-declaration of an account as fraud, and civil consequences because the declaration of fraud works like a blacklisting mechanism that bars the borrowers from accessing credit facilities. The Supreme Court has also made an addition to RBI's 2016 circular. The Supreme Court has now directed that banks will be required to record in their orders the reasons for declaring a particular borrower as fraudulent. The Supreme Court has hoped that this recording of reasons in the order will ensure that the banks don't exercise this power arbitrarily. Now, this should come as a setback to the RBI as well as to the banking system. The central bank had argued at length that this internal mechanism was required to act as an early warning system to alert other banks to risks posed by certain defaulters.